the next case is State of Ohio versus John Pierson then. And each side will have 5 minutes to present, or 5 minutes, 15 minutes to present.
Quick.
Very quick. We'll have 15 minutes to present their arguments, and appellant will have 5 minutes for rebuttal if you so choose. So I would remind you, we are being videotaped. Please don't name any victims and use name any victims, and don't use the names of any children. Sometimes the instructions we give are inapplicable to the particular case, but we try to give them anyway. So would you like to reserve some time?
No, Your Honor, I think 5 minutes will be enough.
Okay, sounds good. Thank you.
Thank you, and good morning. May it please the court, my name is Adam Shalupka, and myself, along with Mr. Hilo, sitting at the table, represent appellate John Pierson in the present appeal. Mr. Pierson was a 69-year-old man, no criminal record. He was convicted after a jury trial of felony in the second-degree possession of marijuana and felony in the fifth-degree possession of criminal tools. Prior to trial, the state of Ohio dismissed what had been indicted as trafficking, drug trafficking. However, I guess beneficial to Mr. Pierson, he was acquitted by the jury of the other indicted count of cultivation of marijuana, a felony in the second degree. Mr. Pierson maintains his innocence in this matter, but however, unfortunately, as a result of the mandatory sentencing requirement on the felony 2, he is currently doing 6 years of mandatory time in the state penitentiary. Today, Mr. Pierson, through myself, we're presenting 3 assignments of error. In a nutshell, all of these assignments of error relate essentially to the property lines of his residence on Station Road in Columbia Station, Lorain County, Ohio. The first assignment of error relates to whether or not the affidavit, our contention is the affidavit for the search warrant lacked probable cause. Specifically, I would like to point out a few things. That the first 5 lines of the affidavit literally state there's no probable cause. The first being an anonymous tip that there was marijuana on Mr. Pierson's property. The second being, I think, 1 or 2 drive-bys by the detective, I believe it was Lonnie Dillon, a member of the Lorain County Drug Task Force. He can't see anything on the property when he drives by. I think it was obstructed by a dirt mound, at least the backyard. Again, just so you know, the tip was that he was growing marijuana on his property. They did
Counsel, let me just stop you. I'm not sure I understand the point you're making. You said the first couple paragraphs show there was no probable cause.
Yes.
But they weren't really relying on that.
They weren't. You're right, Your Honor. Correct. They ultimately
the background of how
they ultimately
transpired.
Yes. So they ultimately relied on the fact that they went to the neighbor, Mr. Louis Broschk, I believe is his last name. He testified at the suppression hearing that his father had told him where the property lines were. In our stance, hearsay, he knew where the property lines were. He did live there or did visit that property for most of his life. He took the detectives onto his property, and from there, the detectives saw and smelled raw marijuana.
Counsel, can I ask you, just probably something I should have asked you earlier, how did your client have standing to challenge the search warrant if presumably this wasn't on his property?
Well, he was ultimately indicted for what was alleged to be marijuana on his property.
I understand that.
So I guess I don't really understand your question.
Well, don't you have to claim a possessory interest in something in order to claim that you have standing to suppress it?
Yes, that is correct and true. However, the indictment came against him, and they were alleging he was possessing the marijuana. Or cultivating marijuana on his property. I don't quite understand why, in so filing a motion to suppress, he is somehow affirmatively claiming and making an admission of guilt that he has the marijuana on his property. He is taking the stance, or he took the stance through his trial counsel that, hey, you are alleging that there's marijuana on our property. We are arguing, and it happened at the suppression hearing as well as trial, that there was no further determination of the property lines. There was no actual determination of whether or not the police and Mr. Brush were on Mr. Pierson's property, and they were seeing this marijuana. quite frankly, from their vantage point, maybe this gets to your question, from their vantage point on the neighbor's property, they couldn't even tell exactly where the marijuana was.
So it could have been on his property, but the state didn't
Correct.
prove it.
And that ultimately, so why that arguments originally get made at the suppression hearing, that the state couldn't show through the affidavit that our affiant actually knew with certainty it was on the property. But then if we go over to the second and third assignments of error, which are manifest weight and sufficiency of evidence, which I present together as they're going to rely on the same set of evidence and facts, I do cite a case that one typically subsumes the other, and usually a manifest or a sufficiency of evidence claim, it's hard to ignore the different standards. However, I do recognize they are distinct legal arguments, as I know pointed out by the appellate. In that case, at trial, the same thing happens. There is no evidence put forth by the state of Ohio to show either actual or constructive possession of the marijuana on the property. They say they pulled marijuana off Mr. Pearson's property, but they never put on any testimony, either whether it's the property recordings, anyone from the auditor's office, there's no map shown. As an aside, I used to be a prosecutor, and we had to prove like a schoolyard spec for drug trafficking. I mean, we had to present someone from the city, we had to present someone from the auditor's office to show us where the property lines were. They didn't do that. They essentially just testified that they went to his property and they seized all of this marijuana, therefore it was his. However, there were a few things that I found quite telling in the testimony, particularly with regards almost to the possession of criminal tools, in twofold. There's nothing in his barn. He's a farmer. He grows trees. There's nothing in his barn, and for that matter his house, indicating marijuana or drug usage. There was an actual hose that ran down the hill towards a creek. For some reason, unknown to me, never explained during trial testimony, the officers who searched the property don't even follow the hose to see if it's watering the marijuana or if it's being used in the marijuana. From that standpoint, because they couldn't show where the property lines were, there was testimony that Mr. Pierson, I'll admit, knew that marijuana was grown in the area, but no one at trial, other than Mr. Pierson, adamantly denying the allegations, could show that there was either actual possession of the marijuana plants on his property or even constructive possession. And the constructive possession goes back to this hose. You would think, and I do cite, I believe one case that's kind of instructional on this matter, it's a Cincinnati versus McCartney. It's cited in my brief, and in that case, there was two apartments, one that was vacant across the hall from the defendants, had marijuana plants, I believe, growing in it. There was found to be no sufficiency of evidence in there. Even though it was only, as I believe they state, 6 feet away, they could still show no constructive dominion, no actual dominion over those plants.
Counsel, in terms of property line, let me ask you this. Two was a prosecutor and may have gone about this differently, but in terms of property line, but you can't disregard the fact that the state had what they purported to be as evidence, his admission. Now, I understand he later said that's not what I said, but for purposes of sufficiency, we're to look at that in the way most favorable to the state, which negates the property line problem, correct?
Actually, yes, I would agree with you on that.
And then for purposes of manifest weight, it goes to credibility.
Correct, and for that, my stance with the credibility, I believe his name was Detective Larkin. I mean, there's testimony in trial that he just got fitted for hearing aids. This is an unrecorded statement, this initial statement when Mr. Pierson is in Florida on the phone, allegedly taking responsibility for even cultivating, growing, hoeing, towing the marijuana. We now see the jury, I would hope, could see firsthand that this individual may have had hearing problems. We had no recorded statement. And the second statement and testimony at trial is clarified a little bit as to what Mr. Pierson meant by that about getting an attorney.
But counsel, doesn't that make it clear that the jury did hear that and the jury had the opportunity to consider that?
Yes, and getting to that point, Your Honor, the jury found him not guilty of the cultivating. So if that statement was taking in its entirety to go towards even the possession, the jury somehow heard Detective Larkin saying that, oh yeah, he admitted to having 100 plants and growing this and watering it and doing all this, which should have been able to lend towards a conviction on behalf of the jury finding him guilty of the cultivation, and they don't. So there is some level of an issue to be taken with the credibility of Detective Larkin's statement. I actually think the credibility of Mr. Pierson at trial had been really telling to the jury. On the other hand, I mean, he said he never did any drugs. I mean, that was corroborated by there was no drug paraphernalia in the house, in the house, in the barn, or anything like that. I ultimately think in this particular case, as to the count of possession and criminal tools, the jury lost its way. Yes, they had the ability to weigh these different credibility issues. They had the ability to, to see the court had determined sufficiency of evidence issues to move forward past criminal rule 29. But here,
And you're moving into your rebuttal time, do you want to say that?
I will save it, but just very briefly, Your Honor, before I conclude. Ultimately, the jury could see there was no cultivation from this evidence. I do think it comes down to what I said at the beginning, the property line. There was confusion over where was the property line. Was there constructive possession over this marijuana? It's my stance, Mr. Pierson's stance, Mr. Hyler's stance, that the state failed to demonstrate its burden of proof of actually showing that this marijuana was either under actual possession of the property or under constructive possession by means of essentially not going and following the hose to see where it went. So with that, I'd ask you to sustain the 3 assignments of error and reverse Mr. Pierson's convictions. Thank you.
Good morning, Your Honors. Lindsay Poprocki of the Lorain County Prosecutor's Office on behalf of the state of Ohio. There's no dispute in this matter that the search of John Pearson's property, which yielded the seizure of 244 marijuana plants, was authorized by a search warrant. That warrant is entitled to a presumption of validity, which Pearson must overcome. Despite Pearson's contentions to the contrary, the search warrant was supported by probable cause, and Pearson's motion to suppress was properly denied. This court must consider the lens from which the trial court was required to review Detective Dillon's affidavit in support of the search warrant application to determine the sufficiency of probable cause. In determining the sufficiency of probable cause, trial courts are to employ a totality of the circumstances approach. The task of an issuing judge is simply to make a practical, common sense decision whether, given all the circumstances set forth in an affidavit, there is a fair probability that evidence of a crime will be located in a particular place. Reviewing courts are to be deferential to the trial court's determination and simply ensure that the trial judge had a substantial basis for concluding that probable cause existed. It is under that backdrop that the determination of sufficiency of probable cause is determined.
Counsel, I'd like to ask you a question that Judge Callahan asked of the other side, and that is about the standing issue. That wasn't raised, I understand, but is there something we're missing?
I don't believe so. I mean, Pearson filed a motion to suppress based on the fact that there was no sufficiency of probable cause, and basically he placed that issue before the court, whether there was a suppression issue.
Okay, all right, thank you.
We're submitting that the motion to suppress was properly denied in the trial, and the matter
And you think it was properly before the court even, that there was standing is basically what it comes down to. That he could raise that issue and bring a challenge to the search warrant.
if the marijuana was found on his property.
Thank you.
Detective Dillon's affidavit first set forth that that an anonymous tip was forwarded to the Lorain County Drug Task Force regarding marijuana being grown on Pearson's property, and it stated the address where the marijuana was being grown. Standing alone, the state will note that that anonymous tip did not provide an adequate basis for a probable cause determination, but that Detective Dillon's further investigatory steps in determining probable cause gave him sufficient, warranted the search warrant application. At the suppression hearing, Detective Dillon testified consistently with the facts he set forth in his search warrant affidavit. He verified the anonymous information given to him and demonstrated through his affidavit investigation that there was a fair probability that marijuana would be found in the location articulated in his affidavit, which was specifically the northeast quadrant of Pearson's property. The trial court found Detective Dillon's testimony to be credible, as was within its province to do, and specifically reviewed his affidavit for probable cause under a totality of the circumstances analysis. In doing so, the trial court read the paragraphs of the affidavit in context of one another and as a whole to conclude that based on the totality of the circumstances, there was sufficient probable cause to issue the search warrant for the northeast quadrant of Pearson's property. As did the trial court, this court should reject Pierson's argument that the only statement that could have supported probable cause to search his property was the last sentence in paragraph 6 of the affidavit. By placing the sole focus of his argument on one line of the affidavit, Pierson fails to acknowledge the totality of the circumstances approach that a trial court must take. In conducting probable cause assessments, statements cannot be read in isolation, but rather must be viewed in context of one another as the trial court did. The issuing judge simply made a practical, common sense decision that given all the facts set forth in the affidavit, which must be read in totality, there was a fair probability that evidence of the crime, specifically marijuana, would be found in the northeast quadrant of Pearson's property, which was in fact referenced in paragraph 6 of the affidavit. Upon review by the trial court, the issuing judge properly issued a search warrant upon a finding of probable cause. On alternative grounds, the trial court denied Pierson's motion to suppress by finding that the officers would have acted within good faith on a facially valid search warrant. In his appellate brief, Pierson has offered no argument in opposition to the application of the good faith exception. He's offered no argument in opposition to that good faith exception here or the trial court's decision in that regard. We would ask that the motion to suppress argument be overruled by this honorable court. As to the sufficiency argument, he's challenging the possession element of his convictions for possession of drugs and criminal tools. And possession obviously can be constructive. And in this case, there was sufficient evidence that Pierson constructively possessed both the marijuana plants and the criminal tools which form the basis of his convictions. The state provided ample evidence to show this. The state presented evidence to show that upon entering Pierson's property with the search warrant, detectives gathered near a pole barn and subsequently located a pole barn on Pierson's property and subsequently located and seized 244 individual marijuana plants approximately 50 to 100 feet away from the pole barn in the northeast quadrant of the property, well within the 370 feet of Pierson's property line, which was established by a Lorain County auditor's map, which was presented at trial. Testimony established and photographs illustrated that many of the marijuana plants located in that area were staked into the ground, were 6 feet high, had roots covered in felt fabric. The state presented evidence that while inside that barn, with the consent of Pierson's wife, detectives located and seized 16 felt planting bags, which were consistent with the felt bags observed by detectives while being used to plant and grow the marijuana in the field. They also located buckets filled with water and a tub with a garden hose attached while they were on the back of that barn. Photographs that were shown at trial demonstrated that that garden hose stretched from the pole barn into the plants that were growing in the field. To the extent that Pearson argues that the marijuana plants were not on his property or located within the boundaries of his property, this alone would not be grounds to determine that he was not in possession of the marijuana. The state noted and cited to a case out of the 8th District, State v. Adams, in its brief, where the 8th District found that the weight and sufficiency of the evidence supported a possession conviction based on a finding that the defendant constructively possessed heroin that was found in a mason jar approximately 100 feet from the boundaries of his property when similar jars were found in the defendant's house. So the correlation of evidence found in the defendant's house to the drugs found in adjoining property was still sufficient and to support the possession conviction. Ultimately, the items found in here that were found in Pearson's house and their connection to the 244 marijuana plants located in the field supported Pearson's convictions for possession of drugs and possessing criminal tools. As to the manifest weight argument, we would just submit that the jury was in the best position to determine the credibility of the courtroom testimony, which included Pearson's own testimony. That it also included Detective Larkin's testimony, Detective Dillon's testimony, and Pearson's. The jury resolved evidentiary conflicts in favor of the state, and it was within its province to do so. Pearson has not shown how this is an exceptional case which weighs in favor of him and against conviction. Therefore, we would ask that this court affirm the judgment of the court below.
Any questions? Thank you.
Thank you.
You have 4.5 minutes.
Thank you. Hopefully I could just hit a few points and we'll be done. So I would like to go back to the standing issue of the search warrant. I would just like to, I guess, offer this. This court, if they reverse and choose to overturn these convictions, can do so whether or not they feel the argument on the search warrant is to be sustained or overruled, or whether or not the evidentiary assignments of error should be sustained or overruled. Obviously, we were not counsel in the trial court, and I think during the state's presentation, I believe one of the honorable judges on the bench included, well, why didn't Mr. Pierson raise the issue that it wasn't on his property at the search warrant? I think that's an excellent point. However, I think they chose a different tactic, a different strategy, and we're just focusing on the fact that they were improperly on his property, which Judge Betlesky, actually in his findings of facts and conclusions of law, does say that they may have inadvertently made their way onto Pierson's property because, again, they didn't know exactly where the property lines were. I believe, based on the state's presentation here, that they may have touched upon, or at least began to concede, on the possible actual possession and focus solely on constructive possession. In so doing, they talked about the hose, and that they saw it going towards the marijuana plants, and that is the reason why detectives may have not gone and actually followed it. There was testimony at trial, which I think is important on this point. It was not a weeping hose, and therefore it was not a hose with the holes in it that would water the plants, like almost irrigating the plants. And that was, I think, testified by several people in the trial court. I do want to quickly touch upon the Adams case that they rely on out of the 8th District. I understand the analogy that they're trying to make, but I think it's important that in the Adams case, with these mason jars, there were the same mason jars found in the house. Here, there was no evidence of drug paraphernalia. And there's established in testimony, neither the house or the barn, that would be consistent. I know they're talking about these burlap growing bags. Mr. Pearson's a tree farmer. I mean, these are his tools. These are what he grows on his property. I know that there had, at least through testimony, that there were issues with drugs in the area being grown on surrounding properties. Mr. Pearson even testified to that. For his basis for not being so worried, I know he testified that he felt threatened if he went to the police based on some prior incidents. I think that's irrelevant. We shouldn't hold the fact that he's a tree farmer who has these specific burlap bags for growing trees. That shouldn't automatically assume that he's the one who's growing the marijuana plants when we have no other evidence of drug trafficking, drug paraphernalia, anything of drugs within the barn or within the house.
Well,
And
I can't remember right now, but was there any testimony in regard to the trees that he was growing and what kind they were, and whether there was felt bags around them? I think it was felt.
I believe he said the testimony solely went to the fact that he used those in the process of his farming.
Okay, so there was nothing presented that
I don't-
anything was around and he would demonstrate that he did have the felt around the trees and
Correct.
what
It
kind
was-
of trees he grew even.
Correct. I think it was solely that he used those for the trees that he grew on his property. At least what was found in the farm. He testified, he adamantly denied anything to do with the marijuana. And I'll just point back, the jury at least completely believed that he wasn't cultivating this marijuana. Which is why I believe the confusion, if there was confusion on part of the jury, and when they tried to weigh the evidence in favor of the state or in favor of the defendant, came down to the possession and the property lines, and whether it was actual or whether it was constructive. And here, once again, our request is for you to, no matter, if ultimately this court decides to overturn and sustain our assignments of error and overturn his convictions, it can be done with or without resolving the potential standing in the search warrant issue. And we would simply ask, with regards to the evidentiary issues, that the state failed to meet its burden of proof and production and persuasion during the trial. Thank you.
Thank you both for your presentations. The court will take the matter under advisement and issue a written opinion, and that will be sent to both sides. But also, obviously, you probably know already that we release our opinions online as well, so you can check the Supreme Court website as well if you're really anxious to see its release. But anyway, thank you all for, like I said, for appearing today.